On Andrea Shelton, please. Andrea Shelton is called in 235047. There is no answer in the courtroom. I am asking the bailiff to call into the hall for Andrea Shelton.
Yeah.
Come on up. 235047, the state of Texas versus Andrea Shelton. That's you?
Yes, sir.
And Ms. Smith is the probation officer in this case. I've received a letter dated February 26th that states you are failing to adhere to the conditions of probation, which this court is not happy about. Have you gotten a copy of this? Have you seen a copy of this?
Well, that's the first time I've heard of anything like this.
There's a problem.
What's the problem?
I'm about to tell you. On January 26th of this year, probation office obtained written verification that indicated your last doctor's appointment was on August 28th, 2023. The document advised that you were scheduled to return on December 8th, 2023, but failed to do so to the doctor's office. Is that right?
Yes, sir.
Due to the time frame, this indicates the defendant would be out of her mental medications as of December 8th, 2023. Of course, all medications that are prescribed must be taken. Do you understand?
Yes.
What happened on that?
I haven't missed taking my medication. Every time I go report, I have my medication on me.
This says that you were to return on December 8th, I guess, to the VA.
I haven't missed any appointments.
Did you return on December 8th, 2023 as required? Did you or did you not?
Yes, I did.
This says she didn't.
She told me she didn't. She had to call them and reschedule. I don't know. I think work interfered or something.
Additionally,
I mean, that was so long ago, that I probably don't remember. That was in 2023. We are in 2024.
Are we?
Yeah. So that was so far ago. I haven't missed any appointments.
It was
I
just
did just miss one. I did just miss one appointment, but
it was
I'm
just a few
still
months
current on
ago.
my medication.
It was just a few months ago. It was in December. This also goes on to state that you failed to adhere to the GPS monitoring device. As of Johnny's Auto, on a document provided on January 26th, you were $575 behind on your GPS device payments. Your monitor has been deactivated on that date. Thus, you are not following the condition of the GPS monitoring. Would that be true?
No, it's not, because that wasn't one of my conditions that I signed for. I didn't sign for ankle monitors.
I have the
Lacey, I can't,
the
I don't have
information from
probation.
Johnny's.
Here, can you find the probation order? Quickly.
Good. She was found not guilty by reason of insanity. You're just having probation monitor her.
Oh, okay, she's not on a probation status of any reason.
There's a special
okay.
prosecutor involved. So
Okay, who's the special prosecutor in you? Was somebody supposed to be here?
Anderson from Georgetown. No, sir, I don't think he was notified because it doesn't say on there that. Special
Okay.
prosecutor, but there was.
From probation, what is it that she is ordered to do that she has failed to do? Yes, ma'am.
From what I understand,
Mhm.
she came with a GPS monitor to my office. We were under the impression that it came from the court.
Yeah, I want to know what authority I have over her right now. Does anybody know?
Judge, whenever a person's found not guilty by reason of insanity on a violent crime, you have the ability to either have them monitored outpatient or inpatient, and I think you decided on this one outpatient. But I don't know, as far as if she's not following the regimen, then I think you can place her back, you can change your mind and have a hearing and put her back into.
Yeah, I want to know what my remedies are.
I think that's.
Which is
the
what?
remedy would be to put her back in a hospital, or put her in a hospital if she's not doing it outside. Because it was a violent crime that I think she was charged with.
Okay.
If you did order the GPS device in, looks like October of 2022, so.
All right, that has to get done.
Judge, as far as me, my appointments and stuff with my doctors, I've been going to my doctors. I actually just got on a new medication. And I've been taking my medication. I have just missed one appointment this March, but I haven't been missing any appointments.
The GPS device is what I'm most concerned about, so
Well,
that we know.
Well, the thing is, I'm not on house arrest.
I'm sorry,
Judge.
did you interrupt? Don't interrupt. Let me finish my sentence.
You can-
The court is going to order certain reasonable conditions, and if not, then I will change the order and place you back in confinement in a facility. That's my remedy if you don't follow the rules or if you're defiant. These are easy to follow. They are, let's make sure we know where you are at all times, and you report to the doctor regularly. Otherwise, you will lose your freedom. Is that clear?
I'd rather use lose my freedom than have to walk around with ankle monitor.
Then,
You're not tracking.
then send me an order and we will have a hearing. You're either going to follow the rules or not. It's that simple. Send me an order, we'll have a hearing. I will decide whether she needs hospitalization
Okay.
but defiance is not an option with this board.
Got reviewed by Dr. Buffon in the last year, so you're not worried
Defiance
about
is
my
not,
psychological state at all.
that is all,
Have
that
I
is
been
all.
reviewed?
We will be, you're defiant on the rules. You're not following the
She told
rules.
me I could take off my ankle monitor. She told me that she talked
Is
to me
that
before.
true?
Yes, she told me that she
Johnny's
talked
told
to.
me that they wanted their monitor back because
She's not paying, okay.
And so
Well,
I
you have
told
to
her,
pay
we'll
for the
give it back
monitor to
to
have
them.
it monitored, man. And just your failure to pay, that's your fault. Everybody's got to pay for the monitor. So if you don't have the monitor
Why
on,
would you
that's a
track my
problem.
location?
You're gonna interrupt me we're gonna do this all day?
No, sir. May I speak?
Yes, quickly.
I check in every month with my probation officer. Nobody tells me when to go in and when not to go inside. I don't
I'm
have a
ordering you to
curfew.
have a
I don't have a
GPS.
curfew, sir.
I'm ordering you to have a GPS device. You will pay for it until further orders of the court, so we know where you are. It's that simple. Either do it or not. If it's not done within 2 weeks, let me know. You will be brought here and we will take further hearings up as to whether you should convert your freedom into a hospitalization because you're not following the rules of the court setting. These are simple. These are simple. That is all. Get a resetting. 23 CR 1460 is called the State of Texas versus Rogelio Herrera. That's you?
Yes, sir.
Present with Mr. Grove, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about August 30th, 2023, in Jefferson County, Texas, you committed the third-degree felony of assault on a pregnant person. Well, that's terrible. That's terrible. You make it a practice of beating up on girls, or is that who you beat up on, or do you ever try men? But what do you think about beating up on a girl?
Looking good, sir.
No, it's about as low as it gets. It's like beating up on a child, isn't it?
Yes, sir.
Is that the kind of person you are?
No, sir.
The grand jury said you are. They indicted you for this. That's pretty low. Generally, people who pick on others, their gender and size, the ones who pick on others other than their gender and size, generally are cowards about picking on people who are their own gender and their size. Are you a coward?
Yes, sir.
Why would you assault a pregnant woman?
It was a misunderstanding, wasn't it?
Yes, sir.
Oh, you didn't know she was pregnant?
No, I knew.
Really? Well, there's two life forms there. Are you nodding? Does that mean yes? Can you speak English?
Yes, sir.
I see there's an agreement that's been reached where he would be pleading guilty to a lesser class A misdemeanor. Sell that to me, please, under these circumstances. I don't think it's morally right, but what do y'all want to say?
That's primarily based on my communication with the victim of this case, Judge.
And I've had similar communications, I believe, with the victim, although I did not overhear any of Mr. Ham's, but
She's
she
the
requested.
one that talked me into it, Judge.
She's been adamant that she didn't want to prosecute.
Well, that's not what probable cause affidavit says. Are you telling me at the time of the event, she insisted not to file?
Oh, no, sir. That's not where she was.
That's what
Judge.
you just said.
That was what she told me when we spoke over the telephone. Yes, Your Honor.
Okay, after he'd been in jail and had communications with us, which you're not supposed to have.
No, I didn't have no communication with her, sir.
Judge, I'm the one that's approved this agreement. The reason why I have is he doesn't show to have any record as far as that's concerned. This agreement with the conviction will allow, if he does anything further like this, it will result automatically in a felony, and it abides by the victim's wishes in this regard.
Well, all of us know what the statistics, science shows in this type of behavior. Once you cross the line, you're capable of doing it, and you've shown a propensity, and that generally is women are vulnerable to this person. And I just get the sense he couldn't care less. I just get the sense that beating up on pregnant women are just the kind of thing that he does. What a thug. See, got into a verbal argument over a cell phone code. That's all it takes for you to beat up on a pregnant person? Something meaningless like that. You punched her in the head with a closed fist, causing injury to her. Later, Y'all began arguing again. You threw a multivitamin bottle at her leg, causing a bruise on her right leg. The agreement here is that you would be sentenced to 1 year in the county jail pursuant to the lesser included offense of Class A misdemeanor assault. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily to this Class A misdemeanor? And
Yes, sir.
because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it, discussed it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. So help you God. Is that so?
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes without objection.
No objection.
It's admitted. Do I make a finding that this involves family violence?
You can, yes, sir.
I know I can. Is that,
It's appropriate under these facts, circumstances.
That was not part of our agreement, Your Honor, but I'm not going to object to that.
but does it fit the definition of family violence?
It does, because the relation, it's a boyfriend-girlfriend relationship and he's the expected father.
Right. Okay. There's not an objection to that, correct? You can speak out.
Yes, sir.
Okay. If nothing, battery's low. So you were pleading guilty today voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1. Admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this Class A misdemeanor involving family assault. You were hereby sentenced to confinement in the county jail for 1 year. The judgment shall reflect that this involves a case of family violence, and it will be rendered in the judgment in this case. Do you understand what has happened today, sir?
Yes, sir.
And that is your child.
Yes, sir.
Legally and morally, you should treat your child's mother decently. Three cases are called 23 CR 110, first degree felony, aggravated assault, family violence.
Your Honor, there's two cases pending. That's refiled.
I'm not through. 23 CR 120. We gotta work through these here. Third degree felony, an indictment, a third degree felony of unlawful possession of a firearm by a felon. And in that case, stand by. As the previous case, one or more prior felony convictions are alleged. So this aggravated assault in 110, it's enhanced to, correct me if I'm wrong, no less than 15.
That one, Your Honor, they're not in sequence, so it pushes it up to the.
One level. It's a first degree felony in paragraph 1 with prior felony convictions. It would enhance it to 15
Yes,
to life.
yes, sir.
And then in 23 CR 120, it's a third degree felony with a prior conviction. So that gets enhanced if found guilty of all of that to a second degree felony punishment. And finally, 23 CR 340, aggravated assault, family violence. Again, all of these are on the same date. It looks like on or about February 8th. Yeah. 23. Is this re-indicted
Yes,
from
Your Honor.
110?
That's correct. That's
So
correct.
here,
That's
here, we can shred 110, right? We
yes,
don't need that.
That's correct.
All right. So what did you do? Just add a prior conviction?
No,
From
Your
the
Honor.
first one?
far as this, it had to be re-indicted because it said the previous one, it said caused physical injury, but in this case, it was just exhibiting the weapon and threatening.
So it was also changed from a first degree to a
So
second.
second degree, yes,
So
Your Honor. So it'd be
that's
five
a
to nine.
second degree felony then, but you have 2 prior convictions, which look like they're not in sequence, are they?
No, Your Honor.
So it's enhanced to a first degree felony. So you have a second degree felony punishment and a first degree felony punishment. Unlawful possession of a firearm by a felon and family assault. Okay, so and 110 here, that's gone. That's out of here. So that's not part of the game. We are playing in this case.
You need to make sure, Your Honor, that one is dismissed, 'cause it's still showing up as part of the
Why, yeah,
So we need
that
make
needs to
sure-
be dismissed.
Make sure it's taken. Yeah,
Yeah.
that's part of our request, Your Honor, is to make sure they get, so that's one less money. It's
What are his bonds now, please?
It's like 60 and 10, Your Honor, 60 on the aggravated assault, 10,000 on the felony.
Who set those bonds? Curiously enough, I'd like to know. Because they're woefully inadequate under the circumstances that I'm looking at with prior criminal history and the facts of this case. Here, I'm reading the probable cause affidavit, which I'm sure would have been read, but let's see. Let's see. The victim says to the defendant, she was pregnant. The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her and hit her in her stomach. It was a revolver.
Right over here.
Police show up. She has bruising on her right upper arm, redness to her shoulder, as well as left upper arm. Then it was located and arrested. A silver revolver with a wooden grip was located in the defendant's closet, bedroom underneath some clothes. It was a loaded Taurus 38 caliber revolver. So he was booked in for unlawful possession of a firearm by a felon because he has 2 prior felony convictions. And these facts also resulted in him being indicted for aggravated assault, family violence. Yeah. Anything else? What do you want to add from the state and then defense? Let me hear you.
I mean, Your Honor, again, like you said, I believe they were set way too low in this case. The state.
What are you asking
That on the assault with a deadly weapon, the state would ask for 150,000 and 50,000 on the felon in possession of a firearm.
No, no, we would request a lower amount. We brought this to the attention. We've been in jail for almost a year now waiting.
I don't, so what's the point about that? Doesn't purge the facts.
No, it doesn't, but I was just, it's part of just the narrative to get to everything. It's just. I had to mention
Okay,
that.
narrate.
Your Honor, we have requested set on trial. It was set for, I believe, last week. We were on a trial docket. We did not get reached for trial. This is something we intend to try and get resolved. But in the
I
meantime.
want to ask this. Defendant is not eligible for probation, correct?
Yes, correct, Your Honor. Yes.
There's a gun in his home, right? And it happens to match the firearm that was described by a complainant in another case. So let's talk about the circumstances of this case, if you want to or not. What do you say about the firearm?
Your Honor, it was found, it was not found on him. I would make the argument that there. It was not.
It was his home.
It was,
Who was he living with?
who was it?
I was in the room. It's not
But I mean, who lives there? It's not you. Other people live there.
It's not.
Who?
Or the victim.
The next day, they were there, a couple there, there, so. But Your Honor, that's one of our arguments is that it wasn't found on this person. There's a whole issue back here, custody control.
Which doesn't need to be on this person, right?
No, but you still have,
Okay.
that's true. It doesn't have to be on the person, but you still have to prove the care custody control, and there's gonna be some issues on that. Because it wasn't at his home by himself and there's some other arguments we're gonna make, but we'll make that a trial. It's not for here. But Your Honor, we just requested that we felt that this was too high, especially also we.
What about the assault of allegedly beating on a lady, which is about as ungentlemanly as it gets. The court has little tolerance for a man doing that. Unless he's defending himself, of course, but I can't imagine the way I grew up.
One of
The way
the-
everybody should grow up, where ladies or should be treated like ladies. Those, I guess your story is she beat herself up to impress the police when they showed up. All right.
Your Honor, one of our issues was that currently, like I said, both cases are active. We want to make sure the older one gets suspended. So that takes one less bond off of the table for him to have to pay. Because as we've got here this morning, they were both still technically pending. So that was one of our arguments. And I think the court already ruled.
What about it?
Well, I think the one that's been re-indicted from needs to be dismissed because it's no longer active. But I think
Oh, okay.
court-
Well,
yeah,
that-
yes, yes.
That doesn't make
Procedure,
sense.
yes.
Yeah,
And Your
that-
Honor-
that is certainly correct.
Yes,
He
yes.
doesn't need, that shouldn't be against him, two charges of the same event.
Right.
Costing him, no, that should be erased immediately, and it will be.
Okay.
We'll dismiss that. And Your Honor, it shows in the system that it's not showing a bond on that one in my system. It's showing it added an error to the side and the actual bond
Okay.
is on the new
Okay,
indicted
okay.
case.
Just make sure Joe has that correct. That's what our issue because they try.
It looks
But,
like they're trying. It's probably one of those problems of transitioning in this gigantic data system
Yes.
that we have suffered through in the last few months. But at least they put in something that he is not bond, he is not disqualified or required to set a bond on that case that's still that was to be replaced, that's still floating around in the
Yeah.
data system. So that should not be a prejudice to him.
But Your Honor, his family has attempted to bond him out due to the fact that there is the multiple cases to bond out and the amounts he has been unable to do that. Your Honor, he is from here. He has family here. He has relatives here. Everybody's here. He has connections to the area. He's not a flight risk. There's no doubt about that. So then it comes down to the big question, people always point out the dangers to society. This is a violent crime. We understand, but this is a I would say targeted crime, but this is not a random crime of violence. This is something coming out of a relationship.
Well, I mean, it goes against the whole idea that our American society is built around a family unit.
But
Somebody allegedly beating up on the female portion of the family unit is going to be apt to ruin that relationship and cause hostility. This, I think our moral nature is one of peace in the home, which this defendant is charged with completely and totally eradicating.
Your Honor, I think if the court would lower his bond, but add conditions in there of well, conditions are always in there, but no contact with the victim, obviously stress that. If the court wanted to add a ankle monitor or some other monitoring device to help prevent that or to monitor that. But we would request that it's come down to a lower amount in the range of 20,000. I believe 60,000 based on these facts is high.
They're $100,000 in each case. These are atrocious, but his criminal history especially, he has no room for error. But to allegedly be beating on the family, a family member, and also being charged with a firearm, which has gotten him in trouble in the past. He's a felon, and that is disqualifying him from his privilege and right. And I don't find that to be unusual, unreasonable under this fact situation and his criminal history. Also, if he does post a bond, he must have, he will be placed on home confinement, not the victim's home or the complainant's home, some other place that you are going to live. And you must have a GPS and can only leave home for certain necessities that the court would describe and spell out when and if you are bonded out. Let's set this for trial. Is that what we're doing?
It's already been product.
Let's try to get this as soon as possible.
sir.
And the defendant is ineligible for probation.
Yes, sir.
All right, so let's move forward on these things as soon as possible. All right.